I was invited to give you a taste of a typical law school classroom experience here today, and I thought I would take advantage of this opportunity to do something that's been on my mind for a while. To stand up and to proudly say, God bless America, God bless the Bill of Rights, and thank God for the Fifth Amendment. I'm not ashamed to say I'm proud of the Fifth Amendment, and I'm proud to admit on camera and on the internet that I will never talk to any police officer under any circumstance. The Fifth Amendment to the United States Constitution provides, no person shall be compelled in any criminal case to be a witness against himself. And this unfortunate amendment has gotten a bad rap in recent times. Now, here's the easiest question you'll ever get from a client in all the days of your life. Question, hey, the police are here, they want to talk to me. What should I do? Well, I could give you my answer to that question in case you haven't already guessed it, but why don't we go to a real expert. Justice Robert Jackson, a prosecutor's prosecutor. Like me, he began his private practice in Buffalo, New York, years before I did. And after that, he served as general counsel for the Bureau of Internal Revenue, the U.S. Department of Treasury, the Security and Exchange Commission, Assistant U.S. Attorney General for the Tax Division, later the Solicitor General and the Attorney General of the United States, and then the Chief U.S. Prosecutor for the Nuremberg trials. That's an impressive resume. Years later, when he was a justice on the Supreme Court, Justice Jackson stated, quote, any lawyer worth his salt, today we would say his or her, will tell the suspect, his client, in no uncertain terms to make no statement to the police under any circumstances. There's the title of my talk. I'm here to explain to you the surprising and somewhat counterintuitive and admittedly unlikely reasons why Justice Jackson was right. I'm reminded of this because I'm amazed, we're all amazed, by the frequency with which we see newspaper articles coming out all the time from people who really ought to know better, who say, well, I'll talk to the police. I mean, after all, I'm a senator. I'm O.J. Simpson. I'm an experienced, highly polished individual. I've got a lot of experience with public relations, even criminal defense attorneys. There was a local news story here in the Virginia Pilot just a couple of months ago about an experienced criminal defense lawyer who ended up getting convicted of criminal assault because he talked to the police. He was accused of having assaulted another attorney in the hallway. There were no other witnesses to this. A woman said that he grabbed her by the throat during an argument over a case. He denied it. At trial, it was his word against hers. He said, I did not even touch her. But unfortunately for him, when the police had approached him earlier and said, would you be willing to answer some questions? He said, sure, why not? I'm an attorney. I'm a criminal defense attorney. I'm savvy. I'm sophisticated. I've got oratorical prowess. I'm accustomed to dealing with the police, by all means. And then there was a conversation that was not recorded. When the case went to trial, it was no longer his word against hers, because when he testified at trial, I never touched her. The officer took her to the stand and testified, well, when I met with him, he said he did put his hand on her throat, but just as a joke. Then he had to take the stand again and say, that's not true. I never said that. I never admitted to you that now it's his word against two people. Who's telling the truth? We'll never know for sure. But he was found guilty. You know, the government gets pretty upset when people like me instruct the client, people like me and Justice Jackson. Don't talk to the police. Don't answer any questions. But, you know, they can't have it both ways. You people, you've got 10,000 different ways of convicting us. Good for you. But, you know, with the bitter comes to the sweet. With the good comes to the bad. That's 10,000 different ways my client might unknowingly implicate himself in some sort of a criminal transaction. One of the reasons I decided to give this talk, I recently received a phone call from a former student of mine, a Regent Law School graduate, who may be watching this online. We're putting it on the internet. And he told me, hey, I've been approached by the Internal Revenue Service. They want to ask me a couple of questions. They ask if I'd be willing to. But they say that I'm not a suspect. And I know in my heart I don't think I've done anything wrong in violation of the Internal Revenue Service provisions. Lord have mercy. There's no man on earth, there's no woman in this country who can honestly say with complete confidence, I know I have never violated any provision of the Internal Revenue Code. He said, but they say I'm not a suspect and I know I've done nothing wrong. It's okay if I talk to him? I said, no, you tell them you will not talk to them without immunity. I explained to him why that was true, and he never heard from them again. Okay, why you should never talk to the police. Let me just spell it out for you. Let me make it plain to all of you. These are the top 10 reasons. I don't want to actually really lie to you. I don't really have 10. I don't have time for 10, but I've got time for 8, and that'll be close enough. Number 1, and this really ought to be good enough. Contrary to what you laymen instinctively and naturally suppose, it cannot help. There is no way it can help you. Plenty of folks think that it can, and they're always wrong. You cannot talk your way out of getting arrested. Officer Brook, you've interviewed thousands of criminal suspects. Have you ever, how many times in your experience, have you approached someone, asked if you could ask him some questions because prior to the interview you had some evidence pointing to his possible guilt? And because of the extraordinary persuasiveness and eloquence with which he articulated his innocence, you said, oh, sorry, never mind. Bad call, my bad, I won't. And he talked you out of arresting him.
You know the answer to that.
Never. Never. It never happens. I've often asked other criminal defense attorneys, in all of your experience, have you ever once had a case where you looked back in hindsight and said, thank God my client talked to the police? They laugh at me. They laugh at me. They say, you've got to be kidding me. It cannot help you. You can't talk your way out of getting arrested. And contrary to what you might suppose if you never studied the rules of evidence, what you tell the police, even if it's exculpatory, cannot be used to help you at trial. because it's what we call hearsay. Under the rules of evidence, specifically Rule 801D2A, if you want to look it up, everything you tell the police, as the saying goes, can and will be used against you, but it cannot be used for you. From time to time, I've known attorneys who tried to call to the stand a police officer and say, "Officer, would you tell the jury what my client told you because what my client told him is actually good for my case?" If you tried that at trial, the prosecutor will object to that as hearsay, and the judge will agree. The police will not be allowed, at your request, to tell the jury what your client told him, no matter how good it may be for your case. It cannot help. And that ought to be good enough reason. That ought to be reason enough to keep your mouth shut. Number two, obviously one of the most obvious, if your client is guilty, as many of them are, but even if he's not, even if he's innocent, he may well admit his guilt with no benefit in return. That in more than 25% of all the cases where an innocent man was convicted and then later released from prison after he was exonerated by DNA evidence, in more than a quarter of those cases, these innocent people, people we know to be innocent, made incriminating statements, delivered outright confessions, or pled guilty. How do they do that? He'll tell us all about it, I trust. Here's a couple of famous examples. You can just ask them. You don't have to take my word for it. There on the left was Eddie Joe Lloyd. He was convicted in 1984 of the murder of a 16-year-old girl in Detroit after he wrote to police with suggestions on how to solve various recent crimes. During several interviews, police fed details of the crime to Mr. Lloyd, who was mentally ill, and they lied to him and convinced this mentally ill man that by confessing, he might help them smoke out the real killer. He later signed a confession. It gave a tape-recorded statement. The jury deliberated less than 1 hour before convicting him on the basis of this confession. There was no other substantial evidence against him. The judge said, "I'd hang you if I could," but the death penalty was not available in Michigan at the time. But after almost 2 decades in prison, he was released after DNA evidence proved that this man was innocent and had falsely confessed to a crime that he did not commit. On the right is Earl Washington, who was released from prison just a few years ago here in Virginia after spending 18 years behind bars after being committed of a rape and a murder that we now know he did not commit after having been exonerated by DNA evidence. But this man, Mr. Washington, who was in fact confirmed to be mentally retarded, was able to confess to several crimes at the request of the police, some of which we know he could not have committed. That's the problem. Some of you are thinking to yourself, well, none of this concerns me because I'm not guilty of anything and I never will be and I will never represent people who do. Okay. Let's talk to you people. You innocent folks. Those of you who have never committed a crime and never will, and none of your clients will either. And you wouldn't go out with a girl who did. Fine. You better not talk to the police either, okay? Because number three, we'll put the guilty behind us. Forget about them. Let's talk about innocent people. Number three, even if your client is innocent and he denies his guilt and almost entirely tells the truth, odds are good he will easily get carried away and tell some little lie or make some little mistake that will hang him. Even if your client is innocent and only tells the truth and doesn't say anything that is false. Now, already, mind you, we're pretty well nigh into fantasy land. The odds of this being, anybody being able to pull this off are really quite slim, no matter how innocent they may be. But just the same, let's pretend. Let's assume he gives the police nothing but the truth, and he is totally innocent. He will always give the police some information that can be used to help convict him. Always. The United States Supreme Court, don't take my word for this, in Ohio versus Reiner, the Supreme Court of the United States said, quote, "One of the Fifth Amendment's basic functions is to protect innocent men who otherwise might be ensnared by ambiguous circumstances. Truthful responses of an innocent witness, as well as those of a wrongdoer, may provide the government with incriminating evidence from the speaker's own mouth." See, it's not just some criminal defense attorney telling you this. Ullman versus United States, the Supreme Court said more than 50 years ago, eerily prophetic. They said too many Americans, even those who should be better advised, view this privilege as a shelter for wrongdoers. They too readily assume that those who invoke it are either guilty of crime or commit perjury in claiming the privilege. That's not true, and it never has been. But it gets worse. Can it get worse? It can. Number five, even if your client is innocent and only tells you the truth and does not tell the police anything incriminating, which, by the way, is almost impossible to pull this off. I mean, imagine talking to the police for 2, 3, 4 hours, and somebody like him can't somehow manage to extract from you something that can be used to help convict you. That'd be extraordinary. I don't think anybody's pulled it off. But even if you could pull it off, there's still a grave chance that his answers can and will be used to crucify you in a court of law if the police, no offense, don't recall his testimony with 100% accuracy. Even if your client is innocent and only tells the truth and doesn't tell them anything incriminating, and his statement is videotaped, his answers can be used to crucify him. You might say, wait, how can that happen? I insisted, at my insistence, I called the police and I said, look, if you want to talk to my client, you can talk to him, but only if you videotape the whole thing. I don't want there to be any debate between the two of you over what happened. Okay, we'll videotape the whole thing. If the police don't recall their questions with 100% accuracy, he'll be convicted on that statement alone. For example, suppose a man goes to the police, they say, we're investigating a possible murder, a shooting, And the guy says, quote, "I don't know who killed Jones, Officer Brook, with all due respect. It wasn't me. I've never touched or fired a gun in my life." How can that help incriminate this man? How could that possibly be used against this man to help convict him? You would think it's inconceivable. But it's as easy as pie. All the officer has to do is read this statement to the jury, and then the prosecutor says, "Officer Brook, was there anything about that statement that confused you or surprised you?" "Yes, there was," he says in a moment of sinister, high drama in the courtroom. "And what was that?" And then Officer Brook turns to the jurors and he says, "I never said anything about a shooting. I said we were investigating a murder. He was the one who brought up a gun." Then you turn to your client, and your client says, "That's not true. That's not true. I remember he was the one, or one of the cops. I was with them for 3 hours. One of them in the car said something about, they said they had a witness that I was the shooter." "Okay, I'll put you on the stand." And then your client testifies, "No, they did tell me shooting. They mentioned it before I said anything about a gun. They brought it up first." And then the police said, "That's not true." And now what? It's your word against theirs? For what? You're gambling with your client's life. And police officers can very easily make a mistake like that, just as so many of you did just a few minutes ago, about whether you recalled having heard me say something about somebody actually being shot. Police make mistakes, innocently, inadvertently, unintentionally. Any statement, no matter how exculpatory it may seem on its face, can be used to crucify you all by itself if the police are either willing to lie, not likely, or if they just have an innocent misrecollection of the details as to what they did and did not tell you before you told them what you said. All of these, by the way, all of these problems disappear if you take Justice Jackson's advice and say, "Thank you very much, officer, but no thanks." How about this one? Here we go. Now, here's the most surprising of all. I've saved the most surprising one for last. Let's suppose you've got the following scenario. Your client's thinking about talking to the police. He says, "I've got nothing to hide. They think that I killed somebody in Virginia Beach last night." Well, this is what your client tells you in confidence. "I don't know who robbed that store. It wasn't me. In fact, I've got a pretty good alibi. I wasn't even in Virginia Beach that night, last night. I was 4 hours away visiting my mother in the Outer Banks. Unfortunately, no, I did not pay for gas with a credit card. I used cash, and so I've got no witnesses that can prove I was there except my word, and of course Mama, for what that's worth, which is nothing." So your client says, "So the police want to talk to me, and I want to seem cooperative, so what I'll do is I'll tell them that I was in the Outer Banks last night." Now, there's nothing on its face incriminating about any of that. Let's assume, by the way, that you believe with all your doubt. You've given your client a polygraph exam. You've known him for years. You've been going to the same Bible study for 30 years. You know beyond a shadow of a doubt that he's telling you the truth. And he's not admitting anything. He's not admitting motive. He's not admitting opportunity. He's not admitting that he was there. How on earth could this come back to haunt us? How on earth could this come back to be used against us? Be honest. Raise your hand if you really think the answer to that question is, "I can't see how it could possibly be used against me." You're afraid I'll call on you, right? I won't call on you. "Well, you're wrong. You're dead wrong. You're always wrong. Everything you say, every time you talk to the police, you will regret it." You see, the problem is, here it is. This is the last point. I think it's almost, even if your client is innocent and only tells the truth and doesn't tell the police anything incriminating, and the entire interview, questions and answers are videotaped, even his truthful answers can be helped to crucify even an innocent man. If the police, through no fault of theirs, end up in the possession of any evidence, even mistaken and unreliable evidence, that anything your client told them was false, even if in fact it was true. So my advice to you, Justice Jackson was right. Any sane, competent lawyer in his right mind will always tell every client under all circumstances, "I don't care if you're innocent. I don't care if it's the truth. If it's the truth, great. We'll tell the jury all about it. There'll be time enough to put our cards on the table. But before we get there, I haven't seen yet what the police got. They may have mistaken and confused witnesses who will contradict even the truthful stuff that you say. We have no way to know, no way to predict whether the information that you give them, even if truthful and reliable, will end up unwittingly dispelling our demise. So keep your mouth shut. Don't answer any questions. Let's take the fifth. You'll be glad that you did. God bless America. God bless the Bill of Rights and the geniuses who bequeathed it to us. But now, in fairness, I give equal time, or what's left of equal time, to a police officer who will explain to the extent to which, if any, he agrees or disagrees with anything I've got to say. I have no idea to know what he's going to say, but it'll be interesting. Here, let me give him the microphone. Let's give him a hand. Officer George Brook, the Virginia Beach Police Department.
Are any of you guilty of anything? How many of you drove here today? Anybody go above 55 on the interstate? Anybody drive at home and go above 55 on the interstate? Because if you stay...
Your hands for? I told you, don't
And people are inherently honest, and that's their biggest downfall, okay? They really are. Or they want to tell their story. But everybody does something that they can get in trouble for. I can follow as a police officer when I was in uniform. I could follow a car however long I needed to, and eventually they're going to do something illegal, and I can pull them over. And justifiably illegal to pull them over with. So just be aware of that. Don't think you're so innocent in such a thing. You need to think about those things, and when you do become defense attorneys, which I may, who knows, you need to think about those things for your clients. The other thing you need to think about your clients, and this is going to seem very terse, people are stupid. Your clients are stupid. And I've had defense attorneys come up to me, matter of fact, one on a motion to suppress just Tuesday, come up to me and tell me his client was stupid. Okay? They're very straightforward. They do foolish things. They talk to the police. You're picked up by the police. You're in a little room. There's one chair here, there's a desk, there's another chair. What's the thing you want the most right at that point? To get out of that room. To be out of that room. Think the police officer's shift is ending in 15 minutes. Does a police officer want to get out of that room? My overtime rate's $58 an hour. Do I want to get out of that room? I have no problem. I'll stay there for 10 hours. I'll take that $600. Okay, so I have no motivation to want to leave. You do, and that's how we get you to try to talk. That's my job. The defense attorney's job is to hope they get to their client before I do and make sure they don't talk to me, no matter what. Now, on the other side of it, I don't want to put anyone that's innocent in jail. But I try not to bring anyone into the interview room that's innocent. And there are a couple that I have let walk away because they were innocent. You go in there with your paperwork, you sit down, and you just start doing paperwork. And usually I have a videotape sitting on top of it, just for measure, so they think I have a videotape. And you just sit there. Don't tell them Miranda. Just sit there and wait for them to start talking, because they will. They want to talk. People want to communicate. They hate silence. That's why when people speak, you hear, when they're talking, because they need to fill that void with something. People hate silence. Everything that's said, I write down. Every phone call I make has to have a listening device on it. Is that illegal? How many parties need to know that a phone conversation in Virginia is being recorded? One. Me. I knew it was recorded. Okay, back to the people. Yes, they're stupid. Okay, people are stupid. So people are inherently stupid, especially criminals. Now, and don't get me wrong, there are some very intelligent criminals out there, and most of them work in really big office buildings and wear suits. And I know you're innocent till proven guilty, but it's a jury of your peers. And the perception is if you're sitting next to a defense attorney, you have to prove you're innocent. And that's just the perception of a lot of the jury. No matter how many jury instructions they get, they still perceive that person is a hoodlum, is a criminal, because we don't do interrogations, the police. We do not do interrogations. That's a bad, mean, Nazi kind of word, okay? We do interviews, okay? And you'd be amazed how much difference it makes when you use that one word, vices interrogation. That's the start of what's commonly known as a lie, because we are allowed to lie in interviews. So you don't have to have recordings. You don't have to have videotapes. The police videotapes, that's just extra. If you got that police officer sitting there testifying, you don't have to have that videotape. You got the guy that was right there to tell you what happened. So in support of Professor Duane, everything he says is right. That's what I do. Now, to take away the support, I don't try and send innocent people to jail. That's it. That's all I have.